How are you? Leader. Smoking, how are you? Yes, my name. Judge. Yes, yes. And also Director General of Kenya Judiciary. Okay. She is the chair of this commission. How are you? I like that. Hello, William.
Your Excellency, being established by the Master of Ceremony. Good morning.
And judicial officers present, Honorable Attorney General, Your Excellency, sir, with your permission, allow me to now invite the Chief
Samuel Ruto, Your Excellency, the Deputy President, to the Supreme Court of Kenya grounds.
Honorable Lady Justice Philomena Mbetemwilu, Deputy Chief, a warm welcome as she approaches the stage to make her remarks.
On these grounds, since I assumed office as the Chief Registrar, mark a significant milestone, the Supreme Court at bringing this event to life with such finesse. Registrar of the Supreme Court, whose tireless efforts and registrars, directors, whose collaborative and to all the hard-working members of staff, professionalism shine brightly in all that we do, the court's capabilities and enhancing our service delivery. Members of the organizing committee and all that I have mentioned. Renowned Kenyan hospitality that we take pride in.
While the arms of government are independent, we serve the same citizens and the same republic, and as such, inevitably, all arms are interdependent. I urge each of us gathered here, within the judiciary, the executive, and the legislature, to champion this spirit of interdependence in our approach to public service. As members of the judiciary, I also urge you to continue taking a firm stance against corruption. The Supreme Court has the power to set precedents and to reinforce the standards of integrity and fairness that echo through all sectors of our government. I appeal to all of us in public service to be beacons of honesty and transparency that our citizens look up to and expect. The Supreme Court is the keeper of the promise of democracy and justice. Every decision made here impacts not just today's Kenya, but the Kenya of generations to come. Today, we are on a journey together. The Supreme Court does not exist in a vacuum. It exists in a society to serve the society. The African proverb, which you all know, reminds us that if you want to go fast, go alone. If you want to go far, go together. Let us be steadfast partners in building a just society one where the rule of law protects every Kenyan and guarantees their rights and freedoms. As we continue in this partnership or interdependence, let us commit to strengthening our institutions, enhancing the capacity of our staff, and encouraging a renewed spirit of service to wananchi and for the national interest. This is our collective duty. Together, we can realize a more just, prosperous, and equitable Kenya.
While the Supreme Court and the other courts, especially the High Court also, and the Court of Appeal, have helped us start developing crucial jurisprudence on important issues like public participation, like public interest, and how we handle the tensions between these broad interests with individual rights and freedoms, which are also powerfully protected in our Bill of Rights. I, as a student of law, I'll be interested to, going forward, hear or learn what the Supreme Court and the other superior courts will tell us about, beyond public interest, whether there are other higher interests. And I'm saying this with a bit of bias, Your Excellency, because it's in the public domain. I'm the immediate security minister for our country after you appointed me 2 years ago. And during those 2 years, I have had to ask myself whether the highest interest is the public interest, or there is a higher interest called the national interest. Because the public itself could hurt the national interest. And the Constitution talks about the national interest in two places, at the beginning and also in the chapter on national security. Other than the parameters and principles that the courts are helping us to understand about public interest, are there other higher values, primordial, existential, fundamental principles which are crucial to the existence of Kenya? Because the public can be mobilized or can mobilize itself to do the wrong things that threaten the existence of the state. And therefore, that is the next frontier of jurisprudence I would invite us to start thinking about, and the Supreme Court can help us in that regard. In the short time the Supreme Court of Kenya has existed, the jurisprudence has been quite groundbreaking. And on that front, I think it will be unfair for any assessor to actually fault the performance of the Supreme Court. To deliver the public good called justice, of course, the court has to do that through its jurisprudence and through the decisions they make. The court has also done very well in terms of the infrastructure, the software, the technology bit. And among the arms of government and the agencies of government, I think the judiciary is ahead of the rest of us. I remember my Lord Chief Justice Maraga when we were confronted with the predicament of COVID, issued certain rules, which we now call the Maraga rules, practice rules, which actually made justice, faster, more efficient, more convenient, even if we were all locked down by this public health emergency called COVID. And even after COVID lapsed, it appears that the way of the future in the administration of justice will be through the virtual courts and making sure we spend little time or as less time as possible in physical engagements in courtrooms. So again, on the issue of technology and the software for delivering the jurisprudence or delivering justice, the Supreme Court has done a good job.
For the last 15 years, we have concentrated our infrastructural development in the outlying and marginalized areas, but time has come to direct our attention to the Supreme Court, the Court of Appeal, and the Kenya Judiciary Academy, which have no proper home at all. We appreciate the high-level discussions that were led by Your Excellency this morning to the effect that we should have an engagement between the judiciary, executive, and the county government of Nairobi on this issue. Over the past decade, Your Excellency, ladies and gentlemen, over the past decade, the judiciary has received only 50% of its necessary funding, which has adversely affected its operations. Supporting the judiciary as a public good is crucial, and it plays a vital role in protecting individual rights, promoting economic stability, and maintaining a fair and orderly society. Ensuring adequate funding for the judiciary ultimately benefits everyone and strengthens the foundation of a healthy democracy. We want to change the philosophy that underpins budget allocations to the judiciary so that it is based on the number of judges or cases or the justice needs instead of an artificial or incremental basis. We need to introduce some science and empiricism in financing judiciary needs. Despite the challenges that we continue to grapple with, I take pride in the excellent support that the court's registry has provided to the judges since the court began its operations. The registry at the Supreme Court has successfully adopted technology in its processes, including e-filing, and has expanded its reach to 3 locations through sub-registries, and therefore enhancing convenience for court users. As we celebrate these milestones today, let us renew our commitment to justice and progress.